in case people are coming in who weren't here earlier, we had a very rich session this morning, very kind of intriguing discussion. I'm heartened as a student of NAFTA myself by the way that the debate has shifted away from kind of very superficial things about, you know, normative discussions about NAFTA. Is it good? Is it bad? Who's it good for? Who's it bad for? And I think we're really getting into the heart of the matter, which is the kinds of questions that Louis has raised in his paper, and that our panelists have, you know, I think they've also taken him to task in fleshing out some of these issues. Let me just summarize what I see as the three main issues, and then I'm going to introduce the panel, and we'll just get right into it here. If I understood Louis' paper, basically at the time of the negotiation of NAFTA, politicians locked in a long time horizon. That is to say, they set it up so that the agreement really wasn't very easily renegotiated. On the other hand, they left it loose enough, or if you will, non-binding enough, so that, quite frankly, certain decisions have been ignored with very few penalties. Cross-border trucking in Mexico, softwood lumber in Canada. The U.S. has simply ignored many of those rulings. So, you know, we're kind of betwixt and between here. And I guess the final sort of theme this morning was, should this just sort of fade into the sunset? Will it fade in the sunset, given largely, you know, huge competitive trends now coming from China and Asia, and tremendous competition that both Canada and Mexico face in the U.S. market? I mean, will there be just sort of less structural logic for the three countries to continue conducting business under the supposed auspices of something like a North American Free Trade Agreement? Or is there still really good reasons to tackle some of these institutional issues, as difficult and really kind of deep as they are? I think he's left, Sidney Weintraub, my mentor, who I'm sorry he's not here, but I think his final message, and he is sort of the godfather of NAFTA, is that, you know, the cup is probably still half full as opposed to half empty. He claimed, and I have to agree, that for warts and everything, it has been somewhat of a deterrent to further protectionism. Now, that's hard to imagine. We've seen a lot of protectionism coming out of the U.S. Congress in the last 6 years, but I think that probably NAFTA has been, for all of its weaknesses, a deterrent toward even more unsavory and uncollegial forms of protectionism in certain sectors. So we're going to look at the future of trade liberalization. With regard to NAFTA, I think we'll just go in the order of the panelists. We'll begin with Professor Gustavo Vega, who is a professor and director of the Center for International Studies at El Colegio de Mexico. He's going to be talking about NAFTA's dispute settlement system under stress. It's understatement. Donald McKay, director of the Washington Office, Center for Trade Policy and Law, Carleton University. He's going to be speaking on a common external tariff without a customs union. I think I first met Don years ago when you were at the trade unit at the Organization of American States, so he's coming to this with a long history, a very sort of steep learning curve. And then a very dear friend and colleague, Maurice Robert, who is still in the trade unit at the OAS and is acting chief. She's going to be speaking on adjusting NAFTA to the post-NAFTA web of free trade agreements, or FTAs. So let's begin with you, Gustavo.
Well, thanks a lot for the invitation to Andrew Seeley and the Woodrow Wilson Center. Happy to be here in this interesting conference, and it's a pleasure to address this issue. I've been asked to discuss about the NAFTA dispute settlement system, and the way I'd like to try to answer something that Carol raised in her beginning comments is there a good reason to continue working with these frameworks? I'll try to answer that question, and maybe let me say right away that probably, yeah, there is a good reason, and I'll try to, why, but I'll try to demonstrate that in my presentation. Let me remind you, NAFTA established a highly elaborated system of institutional procedures for the management and resolution of trade and investment disputes. The assumption was that with the increase in trade and investment that the agreement was to generate, there would likely be an increase in the number of disputes, and an effective system to deal with them was a necessary and integral part of the overall architecture of the agreement. As a result of the negotiations, we had a very elaborated decentralized system, which was the result of a complex set of negotiations among the three governments and the private sector in the three countries. And also, as you know, in the parallel side agreements in labor and environmental cooperation, there was also an added system that also was a result of a complex negotiations between the environmental and labor communities among the three countries. The overall purpose of this institutional procedure was to improve the management of trade and investment relations and to accelerate the process of integration contemplated in NAFTA. It also aimed at improving the implementation of labor and environmental legislation, especially in Mexico. How well have these institutional procedures performed the assigned mission since NAFTA went into effect? I am assuming that most of you are familiar with what the dispute settlement mechanisms imply, how they work. I hope so. If not, probably in the question and answer period I can clarify. But I have very little time to get into a lot of details, but I like to get some data as to the results of all of the different mechanisms. When one reads and when one studies the record of disputes related, to chapters 20 and 19, which have to do with the general dispute settlement mechanisms, chapter 20, and anti-dumping or subsidies, application of anti-dumping subsidies, and panels that have dealt with those cases in which authorities apply those and producers complain that the application of those laws were not according to law. One can notice that since the NAFTA was put into effect in 1994 and to 2002, 2003, the system was working relatively well and efficiently, but somehow in 2002, 2001, 2002, it became paralyzed and stopped functioning in an efficient way, especially between Mexico and the United States. And more recently, the paralysis has affected Canada and the U.S. as well as a result of the reluctance of the United States government to comply with the decision of a panel in the softwood lumber case, as we already, some people referred to that. In the case of Chapter 11, similarly, the dispute settlement has been effective in resolving disputes. I would say that even more effective, in fact, than the mechanisms of Chapter 20 and 19, but also in the last few years has become subject to a series of criticisms that have resulted in reinterpretation of some of the provisions by the three governments and continuing pressures to further modify and clarify some of the Chapter 11 provisions. What do I mean when I say the mechanisms up to recently were performing relatively well their mission? In effect, if one reviews the record on the Chapter 20, for example, one can observe that a good number of cases between 1994 and 1998 were resolved in a relatively expeditious and efficient way, either at the consultation, mediating, or at the panel level. Cases of utmost economic and political significance, like the avocado or tomato cases between Mexico and the United States, or the uranium sales case between Canada and the United States, were resolved at the consultative level without reaching a panel. But also, there were also important cases resolved at the panel level. Let me just remind you about the brooms case between Mexico and the United States, and the poultry and eggs case between Canada and the United States. Decisions of panels that were complied with by the both cases, for instance, were against decisions of the U.S. government, and the U.S. government complied with the decisions of the panels to modify their safeguards in the brooms case and the complaints that they had addressed against Canada. One could even argue that the trucking services case, which is still pending from resolution, is a case where the panel process contemplated in Chapter 20 helped to restore momentum for resolution. The same can be said for Chapter 19 cases. Up to 2003, we can see that there were 95 cases under review. Of these, 61 cases had been brought to review decisions of the U.S. authorities, 20 to review Canadian decisions, and 13 to review Mexican decisions. Of the 61 cases, 61 of the U.S. decisions under review by binational panels in 2003, 22 cases had been terminated by the actions of the parties that had started the proceedings. 13 cases had been remanded to the U.S. authorities to take further actions in accordance to instructions of the panels, and 3 had confirmed the original decision of U.S. authorities, and 23 of them were pending to be resolved. What is worth remarking is the fact that of the 13 U.S. remanded cases, several led to a significant reduction of the anti-dumping quotas in favor of Canadian or Mexican producers. At the same time, the same can be said of the remanded cases to the Mexican authorities, which led to outright elimination of anti-dumping quotas in favor of U.S. producers, like in the flat-coated steel case or the high fructose case. Similarly, in Chapter 11, 2004, there were 34 cases under review, and despite the fact that there had been a lot of claims that amounted almost close to $3,500,000 from companies, in the end, in 2004, 3 cases had been resolved, which had led to awards implying $40 million, and that was less than 5% of the amounts that the companies had originally asked for. Some cases led to a lot of criticism because many people thought that, for instance, in cases like metal clad or especially metal clad, the arbitral tribunal had exceeded their powers and their mandate and had adopted decisions that were not accordance to their powers of review. But nevertheless, new decisions began correcting some of the deficiencies that had taken place in some of the panels, and we could see that in the Asinian and in the West Management 2 cases, the panels began adopting very strict terms of review and eliminated any kind of denunciations for the companies. And some of the main criticisms of the agreement were beginning to be corrected by the panels themselves. But in any case, because of those decisions, the governments decided to make some clarifications of the provisions. And for instance, the governments decided the panels could not use any other provisions of NAFTA to apply as a way to consider that there was a NAFTA violation. According to the governments, the panels should restrict themselves to the strict application of Chapter 8 of Chapter 11, and could not apply other. So some of the criticisms began to be resolved. But then something in general, for instance, in Chapter 20 and Chapter 19, something happened in 2000. Earlier, in 1998, 1999, Mexico decided that they wanted to ask for a panel in a very important case for Mexico, which was the sugar case. And what happened was that the U.S. government decided that they would not appoint the panelists, and it showed clearly that there were some clear limitations as to how the panel system and the foundations of the panel systems were in a very shaky foundation. Basically, the system works through a system of procedures in which each of the parties are supposed to appoint panelists when the cases cannot be resolved at the consultative or at the trade commission level. But basically what happens is that there is the delegation, as Louis Bélanger uses, somehow is not clustered in a provision in which, in case one of the parties decides not to appoint the panelists in a particular case, there is an automatic provision that would allow a different authority or the system itself to be able to appoint the panelists. When the United States in the sugar case decided that they did not want to appoint the panelists for that particular case, it showed that something in the design was clearly missing. And then it was clearly revealed that, for instance, a commitment by the 3 governments to establish a list of panelists from which the panelists could be chosen to decide cases in cases that the cases reached the panel system, was not based on a sort of a rule-based system, but it was dependent on the goodwill of the parties. And so that showed that the system was in a shaky foundation. And since then, for instance, with the sugar case, the system has been contaminated. And when I mentioned that in 2002, even though there had been many cases resolved in Chapter 19, there were 23 cases pending, and the reason for that was that the U.S.-Mexican government decided that they would not appoint panels, or the U.S. government was not going to appoint panels until particular issues should be resolved, like the sugar or the other cases that also the United States was interested. So what we noticed was that the system was sort of working well, but it was in shaky foundations. And now I have very little time. What I would argue is that to what extent this system could be perfected. I think that, yes, it could be perfected to the extent that some basic decisions could be taken from the three parties. First, I would argue that if the three parties would accept the fact that to set up a mechanism through which a panel roster could be established from a permanent basis in a way in which a mechanism could be found through which, in a particular case, the parties could resort to a panelist, but in case one of the parties does not appoint a panelist, there would be an automatic mechanism to appoint the panelist from the permanent roster. I think that could be done within the framework of NAFTA, and maybe the mechanism could be strengthened. And what I'm basically suggesting is that probably what we would need is to adopt a similar system to the WTO system, in which panelists are appointed in an automatic way, and if not, there is a general secretariat who can appoint panelists from that roster. I think that process could be easily achieved. And then maybe the mechanism could be resuscitated. I think there is, for instance, there is an added impetus now for that. In the Mexican case, one of the leading candidates has been arguing that Mexico should perhaps unilaterally stop complying with the agricultural provisions, and using the U.S. example of the sugar case and the trucking services. And so I think it would be for the benefit of the three countries that, for instance, the U.S. government might give before the next election, probably some changes could be made in the system so that the automatic appointment of panels, the list that is pending in Chapter 20, and a permanent roster in 19 or Chapter 20 could be established easily, and that could probably restore the efficiency of the system that seemed to be working from 1994 to 2001 and 2003. I'm willing to clarify any kind of questions you may have. Any questions?
Thank you, Gustavo. I think that if one of the U.S. partners is expressing a somewhat optimistic opinion about the possibilities for incremental change, that tells us something. We're going to continue with this discussion about possibilities for incremental change with Don's discussion on the possibilities of a common external tariff in the absence of a formal customs union.
Thank you very much, Carol. If I could ask my friend Louis to hold up his copy of the NAFTA, which he had earlier. Oh, he's put it away.
Couldn't carry the weight anymore.
The weight of it, both intellectually and physically.
It's the French version, but this is not the
that's the French version. Okay. Yeah, that version is actually a third longer than the English version and about equivalent to the Spanish version. Oh no, I know it for sure. The English version of that book is 1,079 pages long. Exactly. The part that I've been asked to speak about today concerns the rules of origin, customs union, common external tariff. Towards the back end of that book, there is an annex, Annex 401, which are the detailed rules of origin which elaborate on the less detailed rules of origin found in Chapter 4 of that agreement. The Annex 401 in that agreement is 189 pages long. It is mind-numbingly complex, and if anybody actually understands that annex, I'd be tremendously surprised. I know of two people who understand it. One is a fellow by the name of Sandy Morose, who negotiated it from the Canadian side. The other was a former U.S. Treasury Department official by the name of John Simpson, who set out in life to become the world's leading authority on rules of origin, and I think he succeeded. The rest of us have not gone anywhere near that issue. What does this have to do with the fundamental purpose of a trade agreement? Fundamental purpose of a trade agreement is so that government can back out of the way to allow the private sector, in areas where obviously there's common agreement, the private sector to move forward. As Robert Wolff so helpfully reminded us a bit earlier, much of what is negotiated, to use Carol Wise's term, fades into a sunset. That is not a bad thing. Bob pointed out elements of Chapter 7, the SPS agreement in the NAFTA, as being completely irrelevant. To his list, I am happy to add Chapter 7 on technical barriers to trade. I would throw into that the NAFTA chapter on intellectual property. I would also throw into that the NAFTA chapter on telecommunications. The IP chapter, simply because it replicated what wound up in the TRIPS agreement. But if you remember your sequencing, the NAFTA was concluded before the Uruguay round negotiations were concluded, and it was unclear during that particular phase of NAFTA whether the Uruguay round would successfully conclude. So we took what was essentially in the then Dunkel text and brought it into NAFTA. The telecommunications chapter, by way of example, is also largely irrelevant, not so much due to policy issues, but due to technological advancements. Cellular phones, voice over internet protocols, all of that sort of stuff. It is actually a good thing when portions of these agreements become irrelevant. Louis asked me to speak about rules of origin and tariffs, two very, very dull issues. In Canada, we have about 8,400 tariff lines. The United States has about 10,000 tariff lines in what used to be known as the U.S. tariff system, USTS. We've all moved to the harmonized system. Mexico's tariff nomenclature expands on that a little bit more. It's in the 11,000 range. The exact numbers don't really matter, but we're talking about between 8,000 and 10,000 tariff lines. On the Canada-U.S. side, where my statistics are stronger, I apologize, I don't have the full statistics vis-a-vis Mexico. 30% of those tariffs on both sides are already MFN free. So out of the known universe that we have to deal with or think about, 30% off the top is off the table and no longer an issue. For 40% of the tariff schedules held independently by Canada and the U.S., the difference, the absolute difference, is 2 percentage points or less. In both Canada and the U.S., the historical reason, or one of the historical basis for a tariff in the first place as a source of government revenue, has almost completely lost its total relevancy in terms of government revenue. I don't know if anybody studied it, but I suspect it probably costs our two respective administrations more to collect the tariff than is actually brought in by the tariff. But that would be an interesting issue for somebody to study. If there were a customs union within the North American economic space. What might we expect the economic benefits to be? I'm sorry, just before we get to that, back to my Annex 401 and the 189 pages. What is the cost of compliance of the rules of origin in this particular free trade agreement? Again, studies have been conducted on this, not by myself. This is, again, not an area I'm super strong in. But the studies tell us that the cost of compliance is between 1.4 and 5.7% of the value of exports. If the cost of compliance creeps up either on a firm level or an industry level to anywhere near the MFN tariff, of course, the exporter, shipper, producer will make a logical choice. Not all choices are logical, but will make a logical choice to trade under MFN rules rather than under preference, and in that sense the agreement is irrelevant to them. The economic modelers tell us that the simple average of the Canadian tariff is 5.1%, the U.S. tariff is 3.6%, the Mexican tariff, again, I apologize, I don't have the figure. The Mexican case is also complicated in more recent times by the large number of bilateral agreements that Mexico has in fact concluded, and therefore simple averages and applied averages of Mexican tariffs are a little bit difficult to figure out. That being said, in order to achieve a customs union and to reduce the compliance costs of the rules of origin, what you need to move, obviously, are your MFN tariffs. You need to move them in such a way as no additional barrier is presented to third parties. If that were done, as opposed to how it would be done, this would imply a movement on the Canadian part of 2.1 percentage points, a movement of the U.S. tariff of 0.6 percentage points, and a movement of the Mexican tariff of 5.7 percentage points. You don't need to remember the actual numbers. What would happen as a consequence? Canadian trade flows would increase by 13%. The U.S. GDP, remembering we're dealing with a very, very large number here vis-a-vis the GDP, would increase by 0.1%. In the context of a $15 trillion economy, that's a very big number. In the case of Mexico, GDP increases would be on the order of about 5%. Recalling Sidney Weintraub's injunction to us to never forget the United States Constitution when talking about trade policy, particularly in this economic space, and the inherent difficulties presented by congressional authority in this area, the question comes up, how do you achieve any sort of effective customs union even if you don't achieve a formal customs union? I don't have the full answer to that, but I suspect that the answer lies in bilateral, unilateral initiatives. The NAFTA, for all intents and purposes, actually already contains a singular customs union example in the area of computers. It does so because of a mistake that we made in the original Canada-US Free Trade Agreement. In the original Canada-US Free Trade Agreement, when we got around to negotiating computers, we adopted a value-added approach to trying to figure out rule of origin. And we said in the original Canada-US FTA that the motherboard in a computer must be produced within the economic space that we were talking about. Lo and behold, a couple of years later, the price of a motherboard and the value of a motherboard relative to everything else in the computer dropped off significantly. And the rule of origin made no sense. The NAFTA, we took a leap and, in essence, concluded with what is an effective customs union for that one product. I suspect, and this is by way of a proposition more than by way of a fully studied conclusion, if we want to test the proposition as to how you come forward or move towards an effective customs union, let's try it on a sectoral basis. We can't do it in agriculture. Agriculture, we have an awful lot of problems other than the tariff. We have a U.S. domestic subsidy regime that is vastly different from that practiced in either Canada or Mexico. In Canada, we practice a wonderfully economically illogical policy called supply management. That's another problem for doing anything in that area. The third problem on the agricultural area would be the Canadian Wheat Board, which is an entity that is loved to be hated here in the U.S. in particular. Agriculture is a difficult place to do this. Shipping. Tariffs in the U.S. on ships are 25%. In Canada, they're less than 0.5%. Trucking. U.S. has a 25 or 15 percentage point tariff on trucks. It goes back to a long-standing dispute with the European Union, in fact. The automotive sector, Chapter 87 of the Harmonized System. You have an industry that is already fully integrated on the production side. You have an industry that has changed dramatically in the 12, 14 years since NAFTA was implemented, particularly in the sense of the full domestic location of what previously were exporters from Japan or South Korea into the North American economic space. You have an auto industry that is desperately in need of any and all assistance that it can get, as evidenced by recent stock prices of Ford, General Motors, and other Delphi and other associated stocks. How do you do it? I think the only way that you do it is unilateral moves by the U.S.'s two partners, invoking Sydney's warning about going anywhere near areas of public policy on which, at the moment, or on which the United States Congress has to give a definitive view. I think it's an initiative that you try out on a sectoral basis, first by Canada, first and second by Canada, and then we see what happens. Thank you very much.
Thank you, Don. And now we're going to turn to Maurice Robert, who's going to talk about the other angle on establishing a common or a lower common tariff, which is the web of free trade agreements, or FTAs, that have, since the negotiation of NAFTA, cropped up in the form of bilateral agreements that each of the NAFTA countries have pursued with outsiders of the NAFTA bloc.
Thanks a lot, Carol, and thanks to Andrew and David, and also to Louis for the invitation. This morning I will speak in a personal capacity, more as a student of NAFTA and trade agreements in the Americas than as a staff of the General Secretariat of the OAS. I want to talk about the two parallel tracks that we have witnessed since the mid-1990s. Today, 12 years after the entry into force of NAFTA, And also 12 years after the first summit of the Americas, which launched the FTAA process, increasing trade among countries of the hemisphere remains a top priority. This explains why countries in the region are increasingly aware that signing trade agreements and having access to markets, while necessary, is not sufficient. They know that they need to implement a complementary policy agenda to help their economic agents become more competitive and reap the benefits of these agreements. This is why, starting with the CAFTA-DR free trade agreement, these countries, particularly those negotiating an FTA with the US, have included a formal mechanism aimed at addressing trade-related capacity-building needs during the negotiating phase and the implementing phase of the agreement, as well as during the transition to free trade, with the objective of improving these countries and their firms' competitiveness. So, again, what, if anything, has anything changed since 1994? Well, the FTAA process, the hemispheric process, is at a standstill since February 2004, even though in Mar del Plata, at the Summit of the Americas in November 2005, an overwhelming majority of countries have expressed the view that they were ready to resume negotiation, and they asked Colombia to undertake consultation post-Hong Kong on how to do this. And this is where we are now. That's the first track. The second track is the proliferation of free trade agreements in the Americas. First, with Mexico exporting the NAFTA model to Latin America, and then Chile and Central America following. And early 2001, there was a major turning point when the United States, with the arrival of Bob Zoellick as the new USTR, started also negotiating a bilateral free trade agreement. Bob Zoellick said, but the U.S. at the time said that the U.S. was falling behind the rest of the world when it came to trade liberalization. He noted in 2001 that out of the 130 FTAs, U.S. was party only to 2, NAFTA and Israel. And he also noted that this, quote-unquote, inaction was hurting American businesses and workers. So with Zoellick, with USTR, the U.S. administration decided to move on multiple fronts, multilaterally with the WTO, regionally, and also bilaterally, and to advocate what was known at the time as competitive liberalization. So if one looks at the map of the Americas now, what do we have? In the north, we have the NAFTA, the mother or father of all the other agreements. Central America, with the CAFTA and Dominican Republic, have, and they are in the process of implementing this agreement, a more modern trade agreement that was, as you all know, negotiated recently. And then going south, Panama is about to complete the negotiation with the U.S. In Central America, you have also the Mexicans have a free trade agreement with the 5 Central American countries. Mexico is in the process of completing an agreement with Panama. Chile has negotiated a free trade agreement with Panama. Going south, again, in South America, Peru completed a free trade agreement, concluded the negotiation of a free trade agreement with the U.S. in December, and Colombia a few days ago. Ecuador is hoping to do the same within the next few weeks. And then we go further south, we have Chile, which was the first among the post-NAFTA partners for the U.S. So what's left? If you think about particularly the U.S. Achievement with respect to negotiating free trade agreements in the Americas. There's CARICOM. CARICOM is thinking, the Caribbean, English-speaking Caribbean countries are thinking of maybe going that route depending on what happens at the hemispheric level. And then you have the Mercosur countries, some of which, like Uruguay, there are people in Uruguay, some ministers, they have indicated that they would like to eventually negotiate a free trade agreement with the United States, even though this may not be on the agenda for the time being. So all these agreements are similar to NAFTA, but since they were negotiated 10 or 12 years later, obviously they go beyond NAFTA, as some of the speakers before me have noticed, particularly with respect to IPR, also with respect to labor and environment, because these two elements are within the body of the agreement. But let me say, talk about one particular chapter where NAFTA has been able to make changes to the agreement without amending the agreement, and that's the investment chapter. You have in the investment, the famous chapter 11, you have one provision that allows the Free Trade Commission to meet and to provide clarification with respect to the chapter. And as you know, the three NAFTA ministers have done that in 2001 with respect to transparency and one particular issue, which is fair and equitable treatment. We won't get into the specific because it's rather technical, but there is there the possibility of adding what is known as an interpretative note, which clarifies the chapter. And this has been rather useful in the context of the investment chapter. How to adapt the NAFTA without amending the NAFTA to the new environment, that is one way of doing it. And this could be done also with respect to one issue that was mentioned by Louis at the very beginning of this session today, which has to do with expropriation. Expropriation has become, or was a few years ago, one very hot issue with respect to whether NAFTA was good or not, whether NAFTA was with respect to the issue of the right to regulate of sovereign countries and how NGOs would see the NAFTA. In these new trade agreements, what has been done is that countries have clearly stated that the right to regulate of a sovereign state is as important as protecting foreign investors when they go and invest abroad. And there is a clarification to that respect, in the new trade agreements that have been signed by the U.S., but also in the bilateral investment treaty that the U.S. is also signing. The new model, and the same for the Canadian, the equivalent bilateral investment treaty that Canada has as a model. So that is another way of trying to adjust the NAFTA without amending. It's not perfect. So, for instance, there has not been the NAFTA countries, NAFTA ministers have not so far added that particular interpretative note, which says essentially that, and that's important, that non-discriminatory regulatory actions by a party that are designed and applied to protect legitimate welfare objectives, such as, that's an illustrative list, such as public health, safety, and environment, do not constitute indirect expropriation. So where are we going with this web of free trade agreements and the NAFTA and all the other agreements? Could we entertain the possibility that post-Doha, because this year most countries are really focused on the Doha development agenda and trying to really complete the negotiation by the end of the year, or certainly before or early 2007. Could we think of an umbrella agreement that would bring together all these free trade agreements in the Americas. Could we think that, could we entertain the possibility that there is another way to ensure that what Don was talking about, the problems that are raised with rules of origin are taken care of? One way is to essentially eliminate MFN rates, to have 0 rates. So then with respect to rules of origin, you somehow address the issue. I think there are a number of issues that remain to be addressed, and one of the main challenges is, in my view, what happens at the subnational levels. There are a few countries in the Americas, starting with Canada, the US, Mexico, Argentina, and Brazil, where subnational states, provinces, have the power to say yes or no when it comes to liberalizing something like services, investment, or government procurement. And this is where it's going to be fairly difficult to make progress, in my view, but it doesn't mean we won't. But this is one of the challenges that is before us. Thank you.
Okay, thanks to all the panel. We can move to Q&A, and in doing so, could I ask that you just identify yourself and your institution by name? I'm going to just take a list here. Yes, we've got this gentleman back here. Yes. Bob. Okay, yeah. Okay, we'll start with you.
Thank you very much. I'm Isidro Morales from American University. Perhaps when I was listening to Gustavo Vega's presentation, perhaps you have an answer to Louis Bélanger's question. I mean, your major question is that in NAFTA, there's no mechanism in order to transform NAFTA itself. But while listening to you, I realized that perhaps within Chapter 19, there's a mechanism to transform and deeply transform NAFTA, where you were highlighting the fact that there's a crisis in Chapter 19 because the U.S. is reluctant to decide the panelists. I was rereading Chapter 19, Article 1905, even though it's in French, which is much more baroque. It is very clear. It is very clear that when there is such a crisis, there's a solution. I mean, Article 1905, you know that very well, says that in this case, the parties, they can convoke to a commission, or consult a mechanism, and then there are two solutions in case of there's no mutual successful solution. There are two ways of doing. One of it is to apply sanctions. We know that very well. But the other one, which is what I want to argue, is to denounce Article 1904. And Article 1904 is the essence of Chapter 19, which means that parties can denounce this chapter without affecting, so to speak, NAFTA, because as we know, Chapter 19 is an agreement in itself. So there is a kind of solution, which perhaps, and giving my interpretation, perhaps the Mexican authorities, they have not read very well the U.S. message. Remember that in many ways this chapter was transitional because Canada wanted a tribunal. That's what you are suggesting. And at the same time, the U.S. Congress is extremely reluctant to reproduce this chapter in the rest of the agreements that Marie-Robert talked. I mean, there's no Chapter 19 alike in the rest of agreements. So perhaps this chapter is doomed either to disappear or to transform itself in another institution, which could be a tribunal. And now let me just argue why perhaps Mexican authorities are not read, and I would like to hear your comments. Is that, first of all, I mean, they don't like this chapter, the Congress. Secondly, perhaps they are waiting for the Mexicans to convoke for a kind of meeting or kind of informal solution in order to explore what the possibilities are. Of course, it's risky because once you are there, you enter into kind of political negotiation. But the other point is that we have to, and following Bob's presentation, that you have to see it in the context. And just very quickly, I want to finish. The forum shopping that was mentioned. More and more, both Mexico and Canada they prefer the WTO instead of Chapter 19 in order to challenge the U.S. decision. Why? Because in the WTO, you can correct me, you may challenge U.S. decisions according to international law, which is WTO. But within NAFTA, you cannot challenge that. You can only challenge U.S. decisions according to their own legislation, which makes much more attractive the WTO. So at the end of the day, I think that there is a mechanism going to transform NAFTA. Perhaps we are going to suppress this agreement, or we are going to transform this agreement to a tribunal, but that's another negotiation. Thank you. Sorry for that.
Thank you. And this gentleman back here with the laptop, yeah.
Jeffrey Hale, University of Lethbridge. Two questions, one brief comment. First of all, a number of the panelists have referred to the inclusion of a number of provisions in the recent, last 3-4 years, bilateral agreements negotiated by the United States that are not contained in NAFTA. How realistic do you believe it is to take Sidney Weintraub's advice to use parallel topical or sectoral agreements to introduce these concepts as side deals in parallel to NAFTA rather than reopening NAFTA? Second question. I'm sorry Louis isn't, well, Louis is still here, so perhaps he can chip in on this as well. One of the questions with regard to NAFTA accession that has always been an open concept on the table is that if the people of Quebec decided to become an independent country by whatever means, there is an open question as to whether they would be considered a successor nation under NAFTA or whether they would have to negotiate a separate accession agreement. Given the fact that we have representatives from all 3 NAFTA nations here today, could you comment on the likelihood of one scenario as opposed to the other being accepted? And thirdly, a very brief observation. Just as Congress is an obstacle, it's a constitutional obstacle to substantial treaty change in the United States, read Provinces and the Labor Convention's case of 1937 in the same way for Canada.
Thank you, Bob.
Thank you. Well, the answer to the last question is really easy. Whatever agreement was made between Canada and Quebec would be respected by the other NAFTA partners. You wouldn't want to touch that one with a 20-foot pole. I had 2 questions that arose from the panel. If Louis is right that you can have change in agreements through judicial delegation, then where you would look for that presumably would be Chapter 20. And my understanding of NAFTA is that it's not quite a dead letter, but mostly irrelevant. So I'd be interested in hearing more comment on why Chapter 20 is mostly irrelevant. And second, I quite agree that there are ways outside of reforming NAFTA that you could get to something that looks in practice like a common external tariff. And one of those ways would be presumably through the Swiss formula in the market access negotiations in Doha. Is that going to end up being good enough?
Isabel's next. Sorry, Louis.
Just in a follow-up perhaps to what just Robert said, if I heard correctly your presentation, Don, there is, I mean, a practical issue in terms of going through customs union, and the way of doing it is, you know, a common external tariff, whether you do it with unilateral measures, bilateral, or multilateral, okay? There is an intrinsic benefit for trade liberalization. But I also heard you saying something that getting rid of the rules of origin would enhance or, reduce costs of transactions for firms. And somehow this is very much needed, and you used the case of the auto industry. To me, I have to question that in a certain way. Not that the rules of origin would not reduce transaction costs, but I'm not sure how much this is going to make the industry more competitive. And why am I saying this? Because I think it gets me back to the question that I was raising in the previous panel, which we really need to know why we need these instruments for. In the case of the auto industry, the rules of origin had a very specific purpose, and that was temporary protection against Japanese investment during the transition period of liberalization. And this was a protection required because the companies had already made substantial investments to, in effect, have an integrated industry. But my point is that if you look at the history of that integration process in the auto industry, a lot of substantial investments, especially in auto parts production, were inhibited by the fact that political unions in the United States and Canada, the unions, were opposed to huge investments in Mexico in an area that Mexico had a clear competitive advantage. So the question is, and we go back to what Bob was referring to before, is NAFTA the right instrument, to enhance competitiveness of this industry, or even trade liberalization? I think in an industry like the auto industry, you need something else. More kind of political arrangements, perhaps, and we can talk about that later.
Louis? Yeah, I have room for one more on my list, and then I'm closing. We're closing out here. Yeah? All right, you be the last one.
Okay, thank you. On Quebec, I think there's nobody in Quebec that think that, nobody serious enough to think that Quebec would benefit from any successor state kind of status. I think this is a close question as far as I'm concerned. I have some very, very brief questions for each of the panelists. Gustavo, you certainly know that there's a constitutional challenge right now in Washington that has been brought by the U.S. softwood lumber industry, and the basis that that there are a lot of elements that have been brought in this case, but the basis of their argument is that because the Chapter 19 dispute settlement mechanisms means that there is an international body that has the power to judicially review national laws and not international laws. This is unconstitutional in the U.S. And basically, this is due to the fact that there is no NAFTA law. There's not a body of NAFTA law, an international body of law on competition policy that has been negotiated. Do you think that, do you have any thought about this constitutional challenge, but do you think that it would be, or it would have been feasible to include into NAFTA a specific body of law to apply, or are we condemned to have three separate national body of laws that are subjected to judicial review by Chapter 19? Then, if I understand correctly, this is where we are now, because we cannot expect to have any kind of delegations given by Congress in order to manage a custom union. Then we have to go for unilateral actions. So basically, NAFTA is, the limit to where we can go. And then if we want to go further, it won't be trilateral. It may be somewhat bilateral, but more probably it will be unilateral. And so this is the new era now. We go unilaterally, and we have. And so my question is, how politically sustainable is it in Mexico and Canada to go on this direction? For Maryse, I think that you're correct, and I think that the conclusion to what you've presented is that yes, there are dispositions for interpretation in NAFTA, but this interpretation cannot retrieve or add anything to the treaty. And there was one panel in the Pope Talbot case that severely insisted on this. So basically, what is I would like to have your opinion. What all this? So if yes, there is a possibility of interpretations, but not modifications, and yes, all these FTAs have some innovations that NAFTA is not able to benefit from in the long run. What does it mean for NAFTA itself?
My question is for, oh, I'm sorry, Todd Fox, Commerce Department, Office of NAFTA and Inter-American Affairs. My question has to do with where we go from here. So I guess it's primarily directed to both David McKay and Louis Bélanger. Once we sort of run out of countries to negotiate with, I think the question that a lot of people that do these trade negotiations in the Americas has become sort of where do we go next, and absent a real drive to do an FTAA, I think that the area that's very interesting is sort of stitching together the existing bilateral FTAs. Obviously, the rules of origin is a big issue for that because most of our trade is within North America, which has kind of an outdated system of rules of origin vis-a-vis something like what we see in CAFTA, or the negotiations that are ongoing with the Andean countries, which is a much more state-of-the-art kind of system. Curious as to how you view the prospects of stitching together the various FTAs that the U.S. and Mexico and Chile, as well as Canada, have negotiated in the hemisphere, and just where you see that going, if there's any prospect of that actually happening.
Okay, thank you. Great questions. I'm afraid I'm going to have to impose a 3-minute rule on each of you. So, yeah, give it your best in 3 minutes.
Well, Chapter 19, it's a very special chapter. You're right, Isidro. There is no any other agreement that has included that. I think it would be shooting yourself in the foot if you denounce the Chapter 19 because the U.S. has not complied. I think that now, I must clarify, recently the panels have been restarted, and I think the U.S. has seen an advantage of them. But I think that the problem still is pending as to how to create a sort of a automatic mechanism through which, if one of the countries does not appoint, what to do about it, and perhaps create a sort of a permanent roster. Now that there has been experience through the years that you can identify a particular number of people who could be members of that roster and be, neutral, professional, whatever, enough to be able to comply with that. You wouldn't want to denounce the agreement because it's something I think it's important. As I tried to say in my Chapter 20, why is it irrelevant? I think it has to do with the fact that it was negotiated before the WTO, and then the WTO came in, and with a sort of a system which was more effective. And the problem with the Chapter 20 is that it could be interesting because you have a system in which the appointment of panelists is, as you know, 2 countries appoint the panelists of the other country. It's a sort of a different way. It could be useful, but you would really need a permanent roster which you could really utilize, and an automatic system. And unless you have that, it's going to continue being irrelevant. That's, do I still have subwood?
You have about
50 seconds. Okay. Is there a body of law? No. The whole idea of these panels, the delegation, as you know, Louis, is limited to the fact that you can resolve cases case by case. It's a ad hoc mechanism. Now, you could argue that if you read the decisions, you will immediately see that, especially in Chapter 19, that there are 89 cases, whatever, you will see immediately that many cases refer to previous cases as, not necessarily as a precedent, a binding precedent, but normally as something that is there that you have to take into account in deciding the cases. So even though it's not like the European Court of Justice that creates binding precedents, maybe by the sheer fact that there are decisions that are being addressing particular issues, there is a study by Judy Goldstein of Stanford University that shows that many of the cases have had an impact in the way the Commerce Department is deciding cases. So somehow there is an informal kind of jurisprudence that is that is impacting the way the U.S. authorities are utilizing the law. But yeah, you are right. Maybe in the renegotiation of these, you could argue that perhaps the three countries would accept the idea that res judicata or binding precedents might be a way to go and create a substantive body of law. But that's something for the future. I don't have more time to deal with any other questions. I just want to concentrate on that.
A couple of quick comments. With regards to Quebec, how it gets in, if it becomes independent is irrelevant. The reality is economically it would become a part of NAFTA one way or another. So the end result would wind up the same. There's no Chapter 19 in other agreements. Well, quite frankly, Morocco is not Canada and is not Mexico. Mexico and Canada are the U.S.'s two largest trading partners. Morocco is completely insignificant in economic terms. There's no 19 in the U.S.-Morocco agreement. I accept that as a statement of fact. Same sort of view applies to the question of things that show up in other agreements. Could they show up in NAFTA? Well, again, if you're determining a free trade agreement that manages or purports to manage the economic relations between the United States and Honduras, I guarantee you the reality on the ground between Canada and the U.S. and Mexico is going to be vastly different from the U.S. and Honduras. So that explains some of the differences there. Isabel, competitiveness in the automotive sector, so many problems, so few solutions. Absolutely right. If we could bring Lee Iacocca out of his 15th retirement, perhaps that's one solution. No, it's not the only solution. It would remove one very, very small roadblock that particular sector faces. I've saved the last Robert's question on Doha. That is my preferred outcome. My preferred outcome always has been towards liberalization, multilateralism first, everything else as a second, third, or fourth option. I, quite frankly, do not think that Doha is going to be successful. Trade policy in the United States will have to await the third week of January of 2008 before there can be any... 2009, pardon me, I'm sorry, I even put it off by a year, 2009. Yeah. At which point you will have the new Mexican president who will be halfway through presumably his term. You will have a Canadian prime minister, quite possibly the current one, who will have possibly won a majority government at that point. 2009, the question really is, who takes over the Congress and the Senate in 2006? And is the first name of the new U.S. president Hillary or John? John McCain or Hillary Clinton? That's what will determine U.S. trade policy after 2009. Thank you.
Okay, nothing as exciting to say. Louis, with respect to your question on interpretation versus modification or amendment, I agree with you. I mean, obviously, having an interpretative note is not as powerful, if I may say, as having a modification. But that's all we can, that's all we have now. And one thing to remember is what Gustavo mentioned, which is that rulings from arbitral tribunals in the NAFTA do not technically set precedent for the time being. So now, with respect to the last question, where do we go next? And if we run out of countries to negotiate with, what happens? Well, I think I'm an economist by training, so I will make an assumption. Let's assume that the Doha is successful. It's a big assumption, but let's assume. Then what happens to the negotiation, potential probable negotiation between, let's say, the Mercosur countries and the United States? Is it something that will be necessary at that time or not? I see the possibility of bringing together the FTAs negotiated, the recent FTAs negotiated by the U.S. together. As to the other FTAs, those that were signed by Mexico or Chile with other Latin American countries, or Canada with some Latin American countries, it's not impossible, but this would be much more complicated. The U.S. has a very specific template that has evolved a bit, but there is the text is fairly similar from one agreement to the next, so it would be much, much easier to do that for the U.S. But then it brings home the point of having the U.S. as well, of course, the hub in terms of investment and in trading for trade in the Americas, which is what Canada wanted to avoid when it negotiated the NAFTA in the first place.
Okay, well, thank you to all our panelists and to really excellent questions from the audience. And that's it. Thank you for coming.